Chief Justice Roberts attempts to humiliate Denzel Washington, then discovers actor's extraordinary legal brilliance. The marble columns of the Supreme Court stood like silent sentinels as Denzel Washington walked up the iconic steps at precisely 9:17 a.m. The weight of history pressed down on his shoulders more heavily than the leather briefcase in his left hand. Inside that case, 3 years of painstaking research that would either transform constitutional law or become a cautionary tale about celebrities overreaching their expertise. Mr. Washington. Reporters surged forward, microphones extended. Like probing instruments, camera flashes popped in the crisp morning light. Is this a publicity stunt for your next movie? Are you qualified to argue before the Supreme Court? Does Chief Justice Roberts know you're coming? Washington didn't break stride. His tailored navy suit contrasted sharply against the white marble backdrop. His eyes remained fixed on the towering bronze doors ahead. "I'll be addressing the court today, not the press," he said, his voice carrying the same resonant authority that had earned him 2 Academy Awards. "The Constitution belongs to all Americans, not just those with law degrees." As the massive doors closed behind him, silencing the media circus, Washington paused to gather himself. In the Great Hall, he glanced up at the friezes depicting historical lawgivers Moses, Hammurabi, Marshall, and felt the full gravity of what he was attempting. For 3 years, he had lived a double life, celebrated actor by day, law student by night. He had endured the whispers, the mockery, the dismissal by legal scholars who viewed his Howard University law studies as a vanity project. Today would settle that question once and for all. Inside the ornate Supreme Court chamber, the morning light filtered through heavy curtains, casting long shadows across the polished mahogany and red carpet. The room hummed with the low murmur of attorneys and spectators, a sound that fell to absolute silence when the marshal's voice rang out. "The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States, Oyez." Oyez, oyez. 9 black-robed figures emerged from behind the velvet curtain, led by Chief Justice John Roberts. His face was a carefully composed mask of judicial neutrality, but those who knew him well might have detected something else in his expression. As his eyes briefly locked with Washington, something that resembled amused condescension, the justices took their seats, and Roberts began the proceedings with practiced efficiency. "We'll hear argument this morning in Case 22-907, Henderson versus Department of Justice." The Solicitor General had just completed her argument, defending the government's civil forfeiture of the Philadelphia Community Center seized after a single tenant had been arrested for selling drugs in the parking lot. The center had served over 500 children weekly with after-school programs and provided elderly residents with meals and health care services. "Mr. Washington, you may proceed," the Chief Justice announced, the slightest hint of skepticism infusing his tone. The Supreme Court chamber fell silent as Denzel Washington approached the lectern. His tailored navy suit and commanding presence drew every eye in the room. Law clerks exchanged glances, and attorneys straightened in their seats. This was no ordinary oral argument for Henderson v. Department of Justice, a case challenging civil forfeiture laws that disproportionately affected minority communities. Washington stood composed. His portfolio of notes ranged meticulously before him. At 59 years old, his face carried the gravitas that had made him a screen legend. But today he wasn't playing a part. Behind the scenes, he had quietly completed his legal education at Howard University School of Law while maintaining his acting career, a fact known to few outside his inner circle. He had just drawn breath to begin his argument when the Chief Justice leaned forward. "Mr. Washington," Chief Justice Roberts began, not even allowing the actor-turned-attorney to deliver his opening remarks. "The court recognizes your celebrity status, but I'm curious what qualifies someone from your background to advise this court on complex constitutional matters?" A wave of shocked murmurs swept through the gallery. Roberts had broken protocol with this personal challenge, and the underlying condescension was unmistakable. Several justices shifted uncomfortably in their high-backed leather chairs. Justice Sotomayor's eyebrows rose sharply, while Justice Kagan's lips pressed into a thin line. Justice Thomas typically expressionless during oral arguments, glanced sideways at Roberts. The courtroom fell into a tense silence, every eye fixed on Washington. Waiting for signs of embarrassment or anger, law clerks exchanged uncomfortable glances. Veteran court reporters leaned forward in their seats. This was unprecedented. Washington didn't flinch. He maintained direct eye contact with Roberts, a calculated pause building tension in the chamber. When he finally spoke, his voice carried no hint of intimidation or defensiveness, only a measured, resonant certainty that filled the room. "Thank you for the question, Mr. Chief Justice," Washington replied. "While I understand your concern, my submission before this court is based on 3 years of dedicated research into the founders' original understanding of the Fifth Amendment's Takings Clause as it relates to governmental seizure of private property." He gestured to his amicus brief. "My 40-page submission contains analysis of all 27 civil forfeiture cases heard between 1789 and 1850, including historical materials I personally reviewed in the Library of Congress archives. I believe the substance of my argument, rather than my background, should be the focus of today's proceedings." The gallery remained silent, but the atmosphere shifted subtly. Several justices leaned forward, their interest piqued not by celebrity, but by Washington's unexpected composure and apparent preparation. Roberts' expression remained skeptical, his fingers steepled before him. A faint smile played at the corners of his mouth, the look of someone still certain they were about to witness a public embarrassment. "Very well," Roberts said. "You may proceed with your argument." Washington nodded respectfully. "Mr. Chief Justice, and may it please the court, the Fifth Amendment to our Constitution establishes that private property shall not be taken for public use without just compensation. Yet today, through civil forfeiture laws, the government routinely seizes private property without meaningful due process and without demonstrating substantial connection to criminal activity." His voice carried the perfect blend of authority and accessibility, the same skill that had made complex characters relatable to millions now employed to make constitutional principles accessible to the court. In the case before you, the Henderson Community Center served over 500 children and 200 seniors weekly in North Philadelphia. It was seized by the Department of Justice after a part-time maintenance worker sold $50 worth of marijuana in the parking lot, a transaction unknown to the center's directors or staff. Justice Barrett leaned forward. "Mr. Washington, the government argues that civil forfeiture traces back to English maritime law and has been recognized since our nation's founding. Are you suggesting this entire doctrine lacks constitutional foundation?" It was a fair question, but also a test and opportunity for Washington to reveal a superficial understanding. Several spectators in the gallery leaned forward, anticipating a stumble. "Justice Barrett, I am not challenging the historical existence of forfeiture as a legal concept," Washington replied without hesitation. "Rather, I am arguing that its current application has expanded far beyond its historical constraints and original understanding." He turned a page in his notes with deliberate precision. "In the founding era, forfeiture was primarily limited to admiralty cases involving piracy and customs violations, where jurisdiction over foreign owners was difficult to establish. Even then, it was contested. In 1779, during debate over the Articles of Confederation, Abraham Clark of New Jersey objected to broad forfeiture powers, arguing they represented the same tyrannical overreach colonists had rebelled against. Justice Alito's eyebrows raised slightly. This was not the superficial argument he had anticipated. Washington continued. "The expansion of this doctrine to allow seizure of community centers, family homes, and small businesses based on tenuous connections to alleged wrongdoing would be unrecognizable to the framers and fundamentally conflicts with the Fifth Amendment's protections." Roberts' expression had shifted subtly from dismissive to evaluative. He leaned forward. "You're familiar with the Palmyra then, Mr. Washington, the 1827 case?" It was a trap, a deep-cut reference meant to expose Washington's presumed superficial understanding. Several attorneys in the gallery exchanged knowing glances. Roberts was renowned for testing unprepared advocates. with piercing questions about obscure precedents. The Palmyra was a complex maritime case that established key principles of American forfeiture law, exactly the type of arcane legal history that might trip up a celebrity dabbling in constitutional law. Washington didn't hesitate or consult his notes. Indeed, Mr. Chief Justice, on page 23 of my brief, I address Justice Story's opinion in the Palmyra, particularly his distinction between proceedings in rem against property and proceedings in personam against vessel owners. Washington's resonant voice grew more earnest, leaning slightly forward. However, what's particularly relevant is Story's unexplored correspondence with John Marshall 3 weeks after the decision, where he expressed private reservations about the doctrine's expansion beyond maritime law. Story wrote to Marshall, and I quote, "I fear we have loosed a principle that may later be untethered from its maritime moorings." Roberts blinked, visibly caught off guard. Washington had not only anticipated the question, but had gone deeper than expected, citing private correspondence between two legendary Supreme Court justices that few constitutional scholars had ever referenced. "Those letters aren't widely cited in legal scholarship," Roberts noted, his tone shifting slightly from challenging to curious. "No, they aren't," Washington agreed, a hint of quiet confidence in his voice. "I found them during my research at the Virginia Historical Society. I've included transcripts as Appendix C in my brief." Justice Thomas, who rarely engaged during oral arguments, leaned forward with interest. Justice Barrett made a note on her legal pad. The atmosphere in the courtroom had transformed. The anticipated spectacle of celebrity humiliation had become something entirely different. "Mr. Washington," Justice Kagan interjected, "your historical research is impressive, but how do you reconcile your position with this court's precedent in Bennis v. Michigan, which upheld the forfeiture of property, even from innocent owners?" The question cut to the heart of the legal challenge. Challenging a Supreme Court precedent was the third rail of oral advocacy. Experienced attorneys typically tiptoed around such direct challenges. Washington paused, then replied directly. "Justice Kagan, with profound respect for this court's precedent, I believe Bennis was wrongly decided." The blunt response caused several justices to look up sharply. Such directness was rarely heard at the lectern. The 5-4 decision in Bennis represents a doctrinal anomaly that cannot be reconciled with the Fifth Amendment's text, original understanding, or our nation's fundamental commitment to property rights as a bulwark against government overreach. Washington turned a page in his notes. Justice Stevens' dissent in that case correctly identified that the majority opinion created a constitutional framework where, and I quote, "the Constitution provides less protection for the modern automobile than it does for the home and office." Washington paused, allowing the weight of his argument to settle. "I submit that neither the text nor the history of the Fifth Amendment support such a distinction. The founders recognized property rights as fundamental, regardless of whether that property was a ship, a home, or a community center serving vulnerable populations." Justice Thomas, who rarely spoke during oral arguments, leaned forward. "Mr. Washington, you've cited several state Supreme Court cases from the early 19th century that limited forfeiture. Could you elaborate on those?" The question itself was remarkable. Justice Thomas sometimes went entire terms without asking a single question during oral arguments. The gallery stirred with surprise. Washington nodded respectfully. "Justice Thomas, I found 8 state Supreme Court cases between 1800 and 1830 that placed significant limitations on government forfeiture powers. The Pennsylvania Supreme Court's 1822 decision in Commonwealth v. Donahue held that forfeiture required proof of the property owner's knowledge of criminal activity. The Massachusetts High Court reached a similar conclusion in Parker v. Commonwealth in 1818. Without consulting notes, Washington proceeded to detail each case's holdings, dates, and key passages, a feat of memory that caused several law clerks to exchange impressed glances. These state court decisions are particularly relevant because they reflect how the Fifth Amendment's principles were understood by jurists who were contemporaries of the founding generation. Washington concluded, for the next 30 minutes, Washington delivered a masterclass on constitutional history, weaving together founding-era state Supreme Court decisions, Madison's private papers, and previously overlooked historical evidence. His deep, authoritative voice commanded the chamber as he constructed a compelling argument that the current civil forfeiture doctrine had strayed far from its constitutional moorings. Justice Sotomayor leaned forward. "Mr. Washington, your historical analysis is compelling, but let's turn to the practical implications. The government argues that civil forfeiture is a crucial tool for law enforcement in combating drug trafficking and organized crime. How would your proposed constitutional framework affect those legitimate law enforcement objectives?" It was a question that many advocates might have struggled with, balancing constitutional principles against practical law enforcement needs. Washington nodded respectfully. "Justice Sotomayor, that's a critical question. I've analyzed Department of Justice data from the past decade on civil asset forfeiture cases. What's striking is that 87% of forfeitures occur without any criminal conviction. Of those, 63% involve property valued under $10,000, hardly the kingpin assets the program was designed to target." He turned a page in his notes. "Under the three-part test I'm proposing, law enforcement would maintain the ability to seize property with substantial connections to criminal activity, particularly after criminal conviction. This preserves the legitimate law enforcement tool while restoring constitutional safeguards." Washington's command of both historical principle and practical data was visibly impressing the justices. Even the government's counsel was taking notes. The government's seizure of a community center based on a single drug transaction by a building tenant represents precisely the kind of government overreach the Takings Clause was designed to prevent. Washington continued, "When property is seized without compensation or meaningful due process, especially when that property serves a vital community function, we've abandoned core constitutional principles." Justice Alito interjected with another challenge. "But Mr. Washington, our decision in Bennett v. Michigan established that even innocent owners may lose their property. Are you suggesting that precedent was wrongly decided?" Washington had already addressed this question from Justice Kagan, but the repetition suggested Alito was testing his consistency or seeking to trip him up. Washington paused, then replied, with the same direct approach, "Yes, Justice Alito, I am." The blunt response again caused several justices to look up sharply. With respect to the court's precedent, Bennett represents a doctrinal anomaly that cannot be reconciled with the Fifth Amendment's text, original understanding, or our nation's commitment to property rights as a bulwark against government overreach. He continued, building on his earlier response, "The 5-4 split in that decision reflects the constitutional tension at its core." Justice Thomas's separate concurrence in Bennett itself acknowledged historical questions about the doctrine's scope. "I believe a re-examination is not only constitutionally sound, but necessary to restore the proper balance between government power and individual rights." As Washington methodically exposed tensions in the court's jurisprudence, the atmosphere in the chamber transformed completely. The justices, who had initially viewed him as a celebrity dabbling in law, now engaged with his arguments on their merits. Even Roberts' questioning shifted from challenging Washington's credentials to probing the substance of his constitutional framework. "Mr. Washington," Roberts said, his tone now thoughtful rather than dismissive, "you've argued that civil forfeiture, as currently practiced, violates the public use requirement of the Takings Clause. Could you elaborate on that aspect of your argument?" "Yes, Mr. Chief Justice," Washington replied. "The Fifth Amendment specifies that private property shall not be taken for public use without just compensation. The original understanding of public use required that the taking serve an actual public purpose: roads, schools, or other public goods." Washington gestured to his brief. "Today, over 80% of civil forfeiture proceeds flow directly to the budgets of the very law enforcement agencies that seize the property, creating what Justice Kennedy once called a direct pecuniary incentive for seizure. This revenue generation purpose fails the public use requirement and creates precisely the kind of structural incentives for government overreach that the framers sought to prevent." Justice Barrett leaned forward. Your historical research is thorough, Mr. Washington, but I'm particularly interested in your proposed three-part test for constitutional forfeitures. Could you elaborate on that framework? Washington nodded, turning to the relevant page in his notes. Yes, Justice Barrett, I propose that constitutional forfeitures must satisfy three requirements derived from the text and original understanding of the Fifth Amendment. He held up one finger. First, there must be a substantial connection between the property and the alleged crime, not merely incidental or tangential relationships like a single drug transaction. In a parking lot, a second finger joined the first. Second, due process protections must be meaningfully available to property owners, including the presumption of innocence, rather than forcing owners to prove their property's innocence, a concept the founders would have found bizarre. A third finger rose. Finally, forfeitures must satisfy the public use requirement through addressing specific, identifiable public harms rather than general revenue generation for law enforcement agencies. Washington lowered his hand. This framework preserves legitimate law enforcement tools while restoring constitutional boundaries that have eroded over decades. The chamber had fallen into a respectful silence. Several justices were taking extensive notes, a mark of serious engagement with the argument. Even the government's counsel was writing rapidly, preparing for rebuttal. Your research is quite extensive, Justice Kagan noted. Did you work with a team at a particular firm or institution? The historical analysis is remarkably thorough. It was the kind of question that might have been asked of any advocate, but coming after Robert's initial challenge about Washington's qualifications, it carried additional weight. No, Justice Kagan, Washington replied, his voice steady. While I consulted with constitutional scholars to test my theories, I conducted the primary historical research myself over the past 3 years. Between film projects, I spent hundreds of hours in the Library of Congress, the National Archives, and various university libraries examining primary sources. A murmur rippled through the gallery. The image of the celebrated actor poring over 18th century legal texts and correspondence between filming blockbuster movies was striking. My interest in this case stems from my foundation's work with community centers like the one seized in Philadelphia, Washington continued. When I witnessed the impact of these forfeitures on communities already struggling with limited resources, I felt compelled to understand the constitutional dimensions of the issue. Justice Gorsuch, who had been listening intently throughout, leaned forward. Mr. Washington, your historical analysis suggests that the founders would have viewed modern civil forfeiture with skepticism. Yet the government argues that in rem proceedings against property have ancient roots in our legal tradition. How do you reconcile these perspectives? It was a nuanced question that cut to the heart of constitutional interpretation, balancing historical practice against original understanding. Justice Gorsuch, that's an excellent question that goes to the heart of originalist interpretation. Washington replied. The subtle nod to Gorsuch's jurisprudential philosophy didn't go unnoticed by those familiar with the court. The historical record shows that while in rem proceedings against property did exist in the founding era, they were narrowly circumscribed to maritime and customs contexts, where jurisdiction over foreign property owners was difficult to establish. Even then, they were controversial. Washington turned a page in his notes. James Madison's notes from the Constitutional Convention reveal a debate about forfeiture powers, where several delegates expressed concern about potential abuse. Alexander Hamilton, in a lesser-known Federalist Essay No. 83, specifically cautioned against broad forfeiture powers as instruments of arbitrary power. Washington paused briefly. So while the practice existed, its application was limited in ways that would render most modern civil forfeitures unconstitutional by founding-era standards. This is particularly true for forfeitures of community centers and family homes with only tangential connections to alleged criminal activity. Robert's expression had evolved from dismissive to attentive, perhaps even respectful. The intellectual ambush had failed, revealing not an actor playing at law, but a deeply prepared legal mind who happened to be an extraordinary actor as well. Mr. Washington, Justice Thomas spoke again. surprising the courtroom with his continued engagement. You mentioned finding previously uncited correspondence between Justice Story and Chief Justice Marshall regarding the Palmyra decision. Could you elaborate on the significance of those letters to your argument? The question revealed genuine intellectual curiosity from the court's most silent member. Washington nodded respectfully. Yes, Justice Thomas, in the weeks following the Palmyra decision, Justice Story wrote 3 letters to Chief Justice Marshall, expressing concern about potential misapplications of the in rem doctrine. Beyond its maritime context, he turned to a marked page in his notes. In the most revealing passage, Story wrote, "I fear we have established a principle that, if extended beyond maritime jurisdiction, might permit the government powers of seizure that would astonish the framers. The necessity of jurisdiction over foreign vessels should not become precedent for general government power over the property of citizens." Washington looked up from his notes. This private correspondence reveals that even as the court established key precedents in this area, the justices themselves harbored doubts about broader applications, doubts that have proven prescient given today's expansive forfeiture practices. The white light at the lectern illuminated, signaling that Washington's allotted 30 minutes had expired. The Chief Justice, however, did something rare. "Mr. Washington, the court will grant you 5 additional minutes to complete your argument," Roberts said, a remarkable courtesy rarely extended to even the most experienced Supreme Court advocates. Several veteran court reporters exchanged glances. The extension itself was a testament to how dramatically the dynamics had shifted. During Washington's presentation, "Thank you, Mr. Chief Justice," Washington replied with a respectful nod. "I'd like to address the human impact of current forfeiture practices and how my proposed framework would affect real communities." He turned to a new page in his notes. The Henderson Community Center served over 500 children weekly, with after-school programs, provided meals to 200 seniors, and housed a health clinic serving over 2,000 low-income residents annually. Its seizure, based on the actions of a part-time maintenance worker, has eliminated these vital services. Washington's voice carried a controlled passion that filled the chamber. This case illustrates the human cost when constitutional protections erode. The founders enshrined property rights in our Constitution, not merely as abstract principles, but as essential safeguards of human dignity and community welfare. He closed his portfolio deliberately. "The 3-part test I've proposed would restore constitutional boundaries while preserving legitimate law enforcement tools. It would require a substantial connection between property and crime, meaningful due process, and adherence to the public use requirement." Washington looked directly at the Chief Justice. When the government can seize a community center serving hundreds of vulnerable citizens based on a single drug transaction in its parking lot without compensation, without meaningful due process, and with the proceeds flowing directly to the seizing agency's budget, we have strayed far from the constitutional principles this court is entrusted to protect. He gathered his notes with deliberate care. "Thank you for the court's indulgence and attention." The courtroom remained silent. For a moment, the impact of Washington's presentation hanging in the air. The transformation was complete. What had begun as an anticipated celebrity humiliation had become a masterclass in constitutional advocacy. Even the press corps, typically jaded after years of Supreme Court arguments, appeared impressed. Several justices continued taking notes even after Washington had concluded. "Thank you, Mr. Washington," Roberts said as the red light illuminated, signaling the end of the extended time. "Your argument has been most informative. The court appreciates your thorough preparation and contribution to this important constitutional question." It was as close to an apology as the Chief Justice would offer in open court. The subtle emphasis on thorough preparation acknowledged the misjudgment in his earlier challenge to Washington's qualifications. Washington nodded respectfully and gathered his materials, aware that something extraordinary had just transpired. He had entered the highest court in the land, facing prejudgment and condescension. He was leaving it having earned intellectual respect on the merits of his work. As he took his seat, the Solicitor General approached the lectern for rebuttal, her expression betraying concern. "The government's position which had seemed unassailable an hour earlier, now faced a serious constitutional challenge from the most unexpected of sources. Justice Kagan leaned toward Justice Sotomayor, whispering, something that made her colleague nod in agreement. Justice Thomas was still reviewing his notes from Washington's presentation. Chief Justice Roberts sat with steepled fingers, his expression thoughtful. In the press gallery, reporters were already drafting headlines that would capture the morning's remarkable turn of events. A celebrated actor had come to the Supreme Court and delivered one of the most compelling constitutional arguments of the term, transforming not just a legal doctrine, but perhaps the court's understanding of where legal wisdom might be found. Washington sat perfectly still as the government began its rebuttal, his expression revealing nothing. He had spent 3 years preparing for this moment, studying law while others slept, researching in archives between film shoots, enduring mockery from legal scholars who viewed his efforts as celebrity dilettantism. Today, before the highest court in the land, Denzel Washington had proven them all wrong, not through his fame or his commanding presence, but through the power of preparation, intellectual rigor, and a profound respect for constitutional principles. The battle wasn't over. The court's decision would come months later, but something extraordinary had already occurred. In a chamber reserved for legal elites, a man presumed to be merely playing a role had revealed himself to be something else entirely. A constitutional scholar of remarkable depth who had earned his place at the lectern through merit rather than celebrity. As the Solicitor General struggled to counter his historical analysis, Washington allowed himself a moment of quiet satisfaction. The journey that had begun 3 years earlier in the Howard University Law Library had reached its destination in the most dramatic fashion possible, not with applause, but with something far more valuable in this austere chamber: intellectual respect. 3 weeks after oral arguments, Chief Justice Roberts sat alone in his chambers, the draft majority opinion for Henderson open on his desk. The windows of his office framed the Capitol dome, illuminated against the evening sky. He rubbed his temples, confronting an uncomfortable truth. Denzel Washington's arguments had fundamentally altered his thinking on civil forfeiture. His clerk knocked and entered, placing a sealed envelope on his desk. "From Mr. Washington, sir." Delivered by courier. After his clerk departed, Roberts opened the envelope. Inside was a handwritten note and a leather-bound volume of first edition of Justice Joseph Story's Commentaries on the Constitution. The note read simply, "Chief Justice Roberts found this while researching the Palmyra. Thought it might interest you. With respect, Denzel Washington." Roberts examined the book, carefully turning to a marked page. There, in the margins, were handwritten notes by John Marshall himself, questioning the scope of forfeiture powers. It was a significant historical find, one that Washington had chosen to share privately rather than use for public leverage or acclaim. Roberts leaned back in his chair, feeling the weight of his misjudgment. His attempt to humiliate Washington hadn't stemmed solely from intellectual elitism. If he was honest with himself, there had been assumptions about Washington's capabilities based on his profession, perhaps even his race. The shame of it settled uncomfortably in his chest. He reached for his phone and, after a moment's hesitation, dialed his clerk. "Jennifer, please arrange a private meeting with Mr. Washington." At his convenience, 2 days later, Washington arrived at the Chief Justice's chambers without entourage or fanfare. Roberts rose from behind his desk, extending his hand. "Thank you for coming, Mr. Washington, and for the book. It's an extraordinary historical document." Washington nodded, accepting the handshake. "History offers perspective, Chief Justice. I thought you might appreciate it. Please sit." Roberts gestured to the chair across from his desk. As they both settled, an awkward silence filled the room. Roberts finally broke it. "I owe you an apology, Mr. Washington. My conduct during your oral argument was unprofessional and unbecoming of this court." Washington studied him, his expression measured. "May I speak candidly, Chief Justice?" "Please do." "Your attempt to dismiss me wasn't just about my celebrity status," Washington said, his voice calm but direct. "There was an assumption that someone like me, an actor, A black man couldn't possibly have the intellectual capacity to master constitutional law. At the highest level, Roberts flinched slightly but didn't deny it. There were preconceptions at work, unfounded ones. As you demonstrated conclusively, Washington leaned forward. I've spent my life dealing with those preconceptions, Chief Justice, in Hollywood, in academia, and now in law. I didn't pursue legal education for the credential or the attention. I did it because I believe in the Constitution's promise of equal justice. Your work speaks for itself, Roberts acknowledged. The research you presented on the historical understanding of the takings clause is, well, it's changed my thinking on the Henderson case. He hesitated, then pushed the draft opinion across the desk. It was an unprecedented gesture of transparency from the Chief Justice. I'd value your thoughts before this is finalized. Washington's eyes widened slightly as he accepted the document. The majority opinion, authored by Roberts himself, had adopted substantial portions of Washington's constitutional framework. The court would be limiting government forfeiture powers in a 7-2 decision. This will return millions in seized property to communities across the country. Washington said quietly, scanning the opinion. Justice often requires course correction, Roberts replied. I've cited your oral argument for times in the opinion. Your 3-part test will become constitutional doctrine. Washington set the draft down, visibly moved. My father was a preacher and a civil rights activist in the 1960s. He used to tell me that justice sometimes arrives from unexpected directions, but it always arrives if we prepare the way. His voice took on a deeper resonance. He would never have imagined his son's words would shape Supreme Court doctrine. Roberts studied the man across from him, a person he had fundamentally misjudged. Will you continue your legal work? Washington nodded. I'm establishing the Washington Justice Initiative to provide representation in civil forfeiture cases. Law will never replace acting for me, but it's become an equally important calling. As their meeting concluded, Roberts walked Washington to the door. There's a Georgetown Law Forum next month on constitutional interpretation. I'm scheduled to speak. Would you consider joining the panel as equals, discussing the law on its merits? Washington asked pointedly. As equals, Roberts confirmed. Who both have something valuable to contribute. Washington extended his hand. Then I accept. Chief Justice. As Washington departed, Roberts returned to his desk and picked up the story volume, running his fingers over Marshall's handwritten notes. The encounter had forced him to confront his own biases unworthy of the principles he was sworn to uphold. The Henderson decision would reshape constitutional doctrine, but perhaps the more profound change had occurred within Roberts himself. He had attempted to humiliate a man based on appearance and profession, only to discover intellectual brilliance that demanded respect. It was a lesson in judgment and misjudgment that he would not soon forget. Outside the court, as Washington descended the marble steps, reporters clamored for comment on rumors of the forthcoming decision. He simply smiled and continued walking, his briefcase in hand. He hadn't pursued this path for recognition or vindication. He had done it because justice, like great acting, required complete commitment to something larger than oneself, and sometimes that commitment changed not just the law, but the people who shaped it.